Good day to everyone from wherever you may be tuning in today. My name is Mora, and I will be your host for today, representing the Initiative for Global Solidarity, a German development cooperation project implemented by GIZ on behalf of the German Ministry for Economic Cooperation and Development. This is, however, a collaboration event. This webinar is being co-hosted by the Social and Economic Council of the Netherlands, specifically by Dr. Seljan Verdiyeva-Smeets, and with the support of Luz Jacobs. Together, we have prepared this webinar for you today. This is the first of 4 webinar sessions. So if you have registered for this one, you will receive information and invitations to the following webinars. Let me begin by answering the first question of the webinar. What is the purpose of this webinar series? So both the Social and Economic Council of the Netherlands and the Initiative for Global Solidarity have identified the need for a cross-industry exchange platform where companies and other stakeholders can join and share learnings, best practices, and other necessary practical advice on how to enable the access to remedy through grievance mechanisms along supply chains. Furthermore, and in light of the current human rights and environmental due diligence laws emerging in several countries and coupled to the EU directive on corporate sustainability due diligence, we also saw an increased need to raise awareness on what the implications may be for buying companies and their supply chains, how they can move forward in setting up systems that enable remedy. And last but not least, we identified the need to harmonize industry approaches towards access to remedy. This is not the time for companies to endeavor on isolated measures to achieve compliance. This is the time to learn from experience, from already existing systems, and the time to think of industry-wide approaches for the protection of workers' rights along the supply chain. And with this objective in mind, we would like to emphasize also on the recommendations made by international frameworks, including those made by the Accountability and Remedy Project number 3 of the UN Human Rights Office of the High Commissioner, which prioritize the involvement of key stakeholders in the process, such as workers themselves, their representatives, and other civil society members that have a crucial role to play in the local grievance mechanisms ecosystem and in defining appropriate access to remedy. Focusing on all the aforementioned would not only pave the way for more efficient risk management systems and more effective remedy to human rights violations, but it would also help industry pool resources and identify synergies instead of steering industry towards attempting to reinvent the wheel. For this first session, however, we want to concentrate on the following questions, which we hope we can provide answers to. So firstly, what does remedy mean within the framework of human rights and environmental due diligence and its relevance? How do grievance mechanisms fit into remedy? Secondly, what do upcoming local and regional due diligence laws require from companies on remediation and grievance structures, and what does it mean in practice? And lastly, we have invited 2 companies from the textiles and electronic sectors in order to share implementation advice and experience on how to set up operational grievance mechanisms. So how did the companies decide to embark on a HREDD implementation journey? Which path did they decide to take for implementation, and how does it look like? How does the supply chain get involved in the process, and how are local stakeholders engaged? To cover up these questions, we have the following speakers present today. We have Dr. Seljan Verdiyeva-Smeets, Senior Policy Officers from the Social and Economic Council of the Netherlands. We have Gabrielle, Senior Advisor in Human Rights and Business for the Danish Institute for Human Rights. Charlotte Williams, Senior Supplier Engagement Manager for Social Responsibility within Amazon. And we have Simon Kraus, Sustainability Consultant for the s.Oliver Group. But before we dive into definitions and frameworks and a little bit as a preamble, we would like to clarify what we mean when we speak of backup grievance mechanisms. So, and before wanting to steal too much from the actual experts giving us input today, both the UNGPs and the OECD guidelines foresee companies setting up what is called operational grievance mechanisms as part of their HREDD. Now, these operational grievance mechanisms may take different forms and involve different stakeholders in different degrees, in-factory, company-based, industry initiative-based, and third-party operated, amongst others. The textile sector, being one of the sectors with vast experience in the implementation of operational grievance mechanisms, has diffused the term backup grievance mechanisms in order to refer to mechanisms that are anchored outside of the production site or company. Here, the word backup is not intended to be interpreted as replacement or plan B, but rather as complement to other grievance mechanisms, and more specifically as a safety net for workers in their quest towards remedy when violations to their human and labor rights have been violated. Thus, this is the focus that we will be having during today's session: operational grievance mechanisms that emerge and operate from a supply chain perspective. So this term, backup grievance mechanisms, can be used interchangeably with the one of supply chain grievance mechanisms. Now on to our actual experts for today. Our first speaker, Gabrielle from the Danish Institute for Human Rights. Hi, Gabrielle, and welcome. We are very honored to have you here help us set up our theoretical context and scope for today. Therefore, we would like to hear from you on two perspectives anchored within international frameworks. So firstly, from a corporate expectation perspective, what do international frameworks such as the UNGPs say on corporate responsibility to remedy human rights harm or violations when they have occurred within a company's scope of operations or along the operation of its supply chain? How do these responsibility degrees on remediation relate to grievance mechanisms? And could you maybe also elaborate on the effectiveness criteria for grievance mechanisms? And on the other side, we know also under the UNGPs, there is an expectation towards states to make available a smart mix of measures to foster business respect for human rights, right? So one of the elements being through the enforcement of laws on business and human rights due diligence. Now we see a trend of legal developments on HREDD law occurring at national and regional level, such as through the German Supply Chain Act, the new Dutch draft on value chain due diligence, and of course, the conversation has gotten broader since the CSDDD from the EU. So what is the quintessence of these legal requirements? And if a company wants to prepare for this legislation, what does it have to do now? And sorry for the mouthful, on to you.
Great, thank you very much. A very succinct introduction for what I'll be covering today. So what I propose to do is just to refresh our memories on what the UNGPs say in relation to access to remedy, and then also share some, as you say, expectations from the emerging laws before others share some more operational presentations. So I'll be briefly touching on remedy in the UNGPs. Then I'll be covering the involvement framework, which again is a component part of the UNGPs, and what the consequences there are for remedy based on that. Briefly touching on operational level grievance mechanisms and the UNGP's expectations of those and the guidance it gives by the provision of the effectiveness criteria. Briefly giving a survey of recent legal developments and emerging laws, and then rounding off with a few key messages. So to start with a few remarks on remedy generally. The right to an effective remedy for a violation of human rights is a basic legal principle. I think that's worth stating at the outset. It's widely recognised by international human rights treaties, enshrined in international jurisprudence, as well as being one of the three pillars of the UNGP framework. And ultimately, remedy is about corrective action to redress adverse impacts on human rights. And so therefore, it's a core part of respecting human rights and a critical component of responsible business frameworks like the UNGPs. Basic principles of fairness are at the core of international human rights standards on which the UNGPs are based, alongside basic principles of justice. So these principles set out the basic concept that if human rights harms occur, they should be remedied. And I say that just to note that the UNGPs should be interpreted in a manner consistent with these overarching principles. Just as human rights harms can take many forms, remedy can and should take many forms, depending on the particular circumstances. Rights holders, of course, are not a homogenous group. And so remedy for harms won't be homogenous either. Often a combination of forms of remedy will be most effective, and This has been reflected by comments from the UN Working Group, which refer to this using the evocative metaphor of a bouquet of remedies. So different remedies might be appropriate in combination in different circumstances. But to the UNGPs, so remedy is a critical component of the UNGP framework, as we've noted. Pillar 3 of the framework is devoted to access to remedy, setting out both state obligations and business responsibilities. So this is a shared competence between states and business. However, although the UNGPs have a whole pillar devoted to remedy, that shouldn't suggest the remedy should be considered separately from the overarching responsibility of business to respect human rights. Rather, the responsibility to respect is predicated on the principle that a business will take certain actions when an adverse human rights impact occurs. And this includes a responsibility to provide for or cooperate in effective remedy in particular circumstances. So considerations around remedy are inextricably linked to human rights due diligence. Good human rights due diligence is aimed at preventing adverse human rights impacts, but inevitably, even with the best policies and practices, adverse impacts will arise, and this is where the responsibility to provide remedy arises. So essentially, there are two core components under the UNGPs for companies here. So firstly is the responsibility to provide for or cooperate in remediation, where a business causes or contributes to an impact, and use the leverage in relation to impacts to which the business is directly linked via a business relationship. This is the so-called involvement framework, which we'll touch on in a moment. And secondly, to establish operational level grievance mechanisms consistent with the effectiveness criteria set out in the UNGPs. Again, we'll touch on that in a moment. Before touching on the expectations from recent legal developments. But one thing I'd like to sort of say now is that a key message is that although the UNGPs are a solid foundation on which to build when considering how to approach remedy, they don't cover all relevant considerations, and remedy is a much broader concept. So onto the involvement framework. The UNGPs recognise that there are different ways a business can be involved with an adverse human rights impact. It can cause a human rights impact, contribute to a human rights impact, or be directly linked by a business relationship. Where a business has caused or contributed to adverse human rights impacts, it should have a process to enable remediation of those impacts, including providing for or cooperating and remedying those adverse impacts. Where a business is directly linked, there are still important roles that they can play to enable remedy, even if a business may not be expected to provide for or contribute to remedy in those circumstances under this sort of a strict reading of the UNGPs. So as I noted, remedy is a broad concept, and considerations around remedy cannot be reduced to questions of how a business might be involved in a human rights harm under the UNGP's involvement framework. This is a useful analytical tool, but these categories are not distinct, and it's a slightly more complicated calculus than that. And over the years of advising companies on business and human rights as a legal practitioner and at the Institute, I've often received requests from companies for precise indicators of when they're going to fall into the cause bucket, the contribute bucket, or the directly linked bucket. And often these requests are linked to an overarching concern around legal risk. However, although the categories of involvement in an adverse human rights impact contemplated by the UNGPs of causation and contribution and linkage do find some analogies in legal doctrine, they're not strictly legal concepts, and the analogies are not precise. As the UNGPs make clear, the responsibility of business enterprises to respect human rights is distinct from issues of legal liability and enforcement, which remain largely defined by national law. So I think worth noting that an assessment of where a company may fall on the involvement framework spectrum can inform a decision on what steps to take to provide remedy, but this is separate from legal liability. I think that's important to note. To complicate matters further, the three categories of involvement don't constitute rigid categories, but rather exist on a continuum. There's no bright line or simple test to definitively classify an entity's involvement in a given human rights impact. Involvement is context-specific and often shifts over time. To give an example that is often used, if a company's purchasing practices, for example, can be linked to human rights impacts caused by a supplier's practices. For example, by applying cost or delivery timeline pressures to a supplier, which then leads to deleterious effects on labour rights within a supplier's employees. This might initially be regarded as a linkage situation, but if that behaviour and these purchasing practices continue over time, it could slide into contribution. So I think that it's worth considering that these things are always context specific, and it's very difficult to tell exactly when you're going to be one category or another. So because there aren't these necessarily clear-cut answers around business responsibilities for remedy in all situations, the assessment of a business as to when they might be required to provide remedy might depart from the views of other affected stakeholders. So clients and civil society may have a different view of where the business sits on this continuum of cause, contribute, and linkage. And these external perspectives of these kinds of stakeholders aren't necessarily limited by the UNGP's involvement framework analysis. And this may in turn provide an incentive to facilitate remedy, even where it may not be technically required by the UNGPs. So there's a short table here which sort of sets out the kind of calculus that you should be sort of looking at when you're considering the involvement framework. So if you cause an adverse impact, you remedy. If you're contributing to the adverse impact, you contribute to remediation and use leverage. If you are directly linked, you use leverage. But also where there is no involvement technically under the UNGP involvement framework, there may not be a responsibility under the UNGPs, but a business may decide to use its leverage anyway. Again, linking up to these expectations of external stakeholders. So one of the other means by which a company can discharge its responsibilities with respect to remedy is by establishing an operational level grievance mechanism. This is covered off in Guiding Principles 29 to 31. And there is some guidance given by the UNGPs in the form of the effectiveness criteria, which are set out in GP 31. So in order for a operational level grievance mechanism to be effective under the UNGPs, it needs to meet these various criteria, that it be firstly legitimate, enable trust from stakeholder groups and accountable for fair conduct, that be accessible, known to stakeholder groups, and adequate assistance is given to various stakeholders so that they can use it effectively and remove barriers to access, that it be predictable, provide a clear and known procedure, and as well communication of outcomes, that it be equitable, ensure that aggrieved parties have reasonable access to information and expertise and advice and can fairly engage with the grievance mechanism. That it be transparent, so keeping parties informed about progress and providing sufficient information about process and timelines. That it be rights compatible, so ensuring that outcomes and remedies accord with internationally recognised human rights. And that it be a source of continuous learning, so drawing on relevant measures to identify lessons to improve the grievance mechanism, but also to inform the broader due diligence process as well, because the grievance mechanisms can be a really effective way to identify impacts and then address them through due diligence. And then lastly, the UNGPs expect that grievance mechanisms should be based on engagement and dialogue, meaning that consulting the stakeholder groups who are intended to use this mechanism on its design and its performance is critical, as well as using dialogue as a means to address and resolve grievances. So onto legal developments. So there's been quite a lot happening on the legal front as a range of jurisdictions seek to translate the responsibilities of the UNGPs, and in particular the process of human rights due diligence, into legal obligations. And these legal developments also have a bearing on business responsibilities when it comes to facilitating access to remedy or providing remediation. So a range of existing and emerging human rights and environmental due diligence laws provide different requirements around remedy, as well as a range of mechanisms which can be used by affected rights holders, such as complaint mechanisms or remediation mechanisms, and in some cases, a statutory mechanism for civil liability for due diligence failures. And so we've seen developments in France and Germany, the Netherlands, and at the EU level, as well as in some non-EU jurisdictions such as Norway and Switzerland. But today we'll just very briefly survey a couple of the EU legal developments. So the French duty of vigilance law was the first of these to come in 2017. It doesn't expressly include a remediation obligation as part of its broader due diligence requirements. It requires companies, in essence, to publish and implement what are called vigilance plans, which is essentially a plan for due diligence. So it doesn't really include remediation expressly in those due diligence requirements, but it does include a mechanism whereby a company might be liable if harm is caused by a failure to publish and implement a vigilance plan in accordance with the terms of the law. Subsequent laws have been more express about requirements to remediate. So the German supply chain law, which is next in time, requires companies to take immediate remedial action to prevent and or minimize imminent or actual violations. It also requires that companies set up an internal complaints procedure, which can be internal to the company, or alternatively, it can also include participation in an external complaint mechanism, provided that that external mechanism meets certain requirements of accessibility and transparency and accountability. which don't precisely mirror what is in Guiding Principle 31, effectiveness criteria, but borrows a number of these concepts. There is no new civil liability mechanism built into the German Supply Chain Act, but there are, of course, underlying tort avenues. What it does do, however, is provide a scope for representative actions in the German Supply Chain Act in the absence of a new statutory mechanism for civil liability. The EU Corporate Sustainability Due Diligence proposal, which I'm sure everyone here has been following very closely. We don't yet know exactly what it will include because it's still being negotiated, and there are some divergences between the Commission's position, the Council's position, and what we're sort of seeing as the Parliament's negotiating its own position on a number of these points. But I can say that it's likely to include remediation as a part of due diligence. So, for example, on the Commission's text, Article 8, which deals with actual impacts, envisages that one action companies might be required to take is to neutralise the impact, including through payment of damages to affected persons and financial compensation to affected communities, proportionate to the significance and scale of the impact. It's also likely to include a requirement that companies establish a complaint mechanism. Under the terms of the Commission's proposal, this is not a full grievance mechanism aligned with the effectiveness criteria, but rather a more straightforward complaint mechanism. But there is a requirement that it be available to a broad range of stakeholders. There's also a provision for the supervisory authorities, which are required to be established under the law to receive what are called substantiated concerns from a broad range of stakeholders, where a company is considered not to be meeting its due diligence obligations. Again, this doesn't expressly deal with remedy, but it's nonetheless another mechanism that stakeholders can use. And then lastly, there is likely to be a civil liability mechanism. Its precise parameters are being hotly debated as we speak in the European Parliament, and there is some divergence between the Commission and the Council's text on that. So we don't yet know exactly what its parameters will be, but it's still nonetheless likely to be included. And then lastly, very briefly, the Dutch proposal includes obligations in relation to remedy in line with the involvement framework of the UNGPs. It very closely mirrors that text, if not, it precisely repeats it. It also requires that it specifies a number of different potential remediation measures that a company might take, providing some additional guidance there. It requires the establishment of a remediation mechanism rather than a straight complaint mechanism to facilitate remedy. It also envisages civil liability as well. So I see I'm probably at time now, but just to round off with a couple of key messages before I hand over the floor. So each of these emerging laws use the UNGPs as a touchstone. So I think that if in order to prepare for them and in order to meaningfully engage with remedy, the starting point is to go to the UNGPs. However, as I've noted, the UNGPs are not the be-all and end-all when it comes to remedy. They're a good, solid guidance, so you should be guided by, but not limited by the principles of the UNGPs, and don't reduce consideration and engagement with remedy to a simple calculation of how you might be involved using the involvement framework and therefore what you're required to do to remedy. You should also embed remedy considerations at each stage of the due diligence process. The remedy process and due diligence processes should speak to each other. So feedback from grievance mechanisms can be used to inform due diligence. Equally, due diligence can be used to prevent potential grievances, and prevention, of course, is better than cure. It should aim to design complaint or grievance mechanisms in line with the effectiveness criteria and use them to inform your approach. So take the learnings from grievance mechanisms and use that in developing your due diligence processes. And lastly, consulting with stakeholders, particularly when determining what effective remedy might be in a given circumstances, because affected rights holders will know best what effective remedy is for them. So thank you for that. I hope that was useful, and I'll hand back the floor. Thank you.
Thank you, Gabrielle, for setting the scene for us. I think this has been a great overview of how the UNGPs and mandatory due diligence law will be complement each other. And I think we can then move on to Seljan to complement our theory scope for the session. Hello, Seljan, from the Social and Economic Council of the Netherlands. Welcome to your own webinar, now with you in a speaker capacity. Could you please provide us with a bit of fundamental and technical information on the subject matter for today? So what is remedy, and what is the difference between remedy and grievance mechanisms, and what is relevant for companies in the distinction between the two?
Thank you, Maria, and happy to be here. I think Gabrielle provided a very nice bridge to what I'm gonna discuss today. I want to make it applicable to the company context, everything that we are discussing today. So in a company context, when we are talking about remedy, those are the actions that companies undertake to counteract or make good for the harm that already has occurred. And remedy can take many different forms. It can be, for instance, apology, guarantees of non-repetition. It can be rehabilitation, restitution, financial or non-financial compensation. Grievance mechanisms, on the other hand, they are administered by companies alone or in collaboration with other stakeholders, industry association, multi-stakeholder group, and they're designed to receive and respond concerns of others regarding impact of company operations on the external stakeholders. Now, having a grievance mechanism is important, but having accessible grievance mechanism does not mean that company is providing a remedy. So remedy must result in a situation when the right holder is restored to the position prior to the harm. And that means that there are procedural, but also the substantive aspects of the remedy, meaning that what Gabrielle already mentioned, the process, operational grievance mechanism should be effective, and the right holder should have clear lines how to raise their concerns. It should be clear, accessible, transparent, and etc. But it should also be substantive in a way that the rights holder, at the result of the process, should be restored to the position as much as possible to the position prior to the harm. Now, grievance mechanisms have different functions. So we're talking about that one of the functions of the grievance mechanism is a channel through which the right holders, victims can raise concerns about the harm that has already occurred or potentially can occur. But grievance mechanisms is also accountability mechanism for the companies regarding their due diligence and sustainability ambitions, and they also act as a channel through which companies can actually analyze the systematic problems in their value chain, in their operations, and improve their due diligence based on this analysis. And that's something that we see when we are working with companies, that they're sometimes not paying enough attention to that factor. From that perspective, remedy is very important, but grievance mechanism is also a part of your whole due diligence system, and it should not be operating in a vacuum. A few things to mention about what a grievance mechanism is and what grievance mechanism is not. Grievance mechanism is not substitute of proactive stakeholder engagement. Companies are still expected to engage with stakeholders. It can be their suppliers, it can be their workers, trade unions, the local civil society organizations, human rights defenders. Companies are expected to engage with them. And if they are and if within those engagements they hear some concerns about the impact that has already occurred, companies are expected to remedy those situations as well. Grievance mechanisms should not be used to undermine legitimate processes such as the functioning of the labor unions, or grievance mechanisms should not preclude the victim from applying to other legal options such as judicial or non-judicial grievance mechanisms. So victims should always have a right to also use other available legal options other than the grievance mechanism of the company. Another thing is that what fair and just remedy is really dependent on the situation, but it's also dependent on the stakeholder that is in question. For example, a remedy, if you're talking about the remedy for a certain person, can be different what remedy is for a person from a marginalized group, or the same is true, for example, normal landowner or people from the indigenous communities for whom land means so much more. So what a remedy is really dependent on the case of the case in question, but also the type of the stakeholder that is involved in this process. And sometimes what Gabriella mentioned, a bouquet of remedies should always be available. For instance, let's say if there is a case of sexual harassment at the factory, one remedy could be rehabilitation of the female worker through receiving the therapy sessions. And multiple remedies can be involved in this process. So apart from rehabilitation, it can also be used, for example, apology. There can be used guarantees of non-repetition. It can be used criminal sanctions that can be done through the local authorities against the perpetrator. So there can be compensation given to the worker because of this harassment issue. So a range of a bouquet of remedies should always be used in these circumstances. And when we apply this to the supply chain grievances, it's important to understand the relationship of the company vis-a-vis the impact that is occurring in the supply chain. So what Gabriella already mentioned, cause, contribute, and being linked to. In the supply chain situations, most of the times the relationship is either contribute to or being linked to. And in those instances, the importance of having leverage is emerging. So especially if you are a small and medium enterprise and you are linked to a negative harm in your value chain, or you are in the position of contributing to that negative harm, you need to use your leverage to make the parties who are causing and contributing to play their role in remediation. And if you don't have that leverage, it's more difficult for you, especially if you are as I said, small and medium enterprise. So from that perspective, the importance of joining up forces with others in your value chain becomes relevant for you, because once you are together, once you collaborate with other companies from the same sector, you have more leverage on your value chain, and you can play more enabling role in remediation process. Back to you, Maria.
Thank you, Seljan. I think this part of this question and Gabrielle's input plays a huge role in collaboration and considering, the opinions of other relevant stakeholders outside of companies, right? So I think the UNGPs and due diligence law can only offer a framework and a guidance, but remedy is a more complex issue, and grievance mechanisms as well. So the crucial role of other stakeholders is just it's imminent, right? It's something it's beyond a recommendation. I think this has been clear now. This is necessary. But so now we know and are able to distinguish between grievance mechanisms and remedy, right? So you provided us with that. Now, where do I start as a company that wants to set up a remediation mechanisms? What are the key factors here to consider?
Yes, so there are several steps that a company can take if he wants to set up a remediation mechanism, or if you already have a remediation mechanism. These tips could also be useful if you want to improve the process. So start by first analyzing your stakeholders. Who are the stakeholders that can negatively impact it through your business relations, through your value chain. Make the list and look at them and check what kind of characteristics do they have. Do they have, for example, are they people with disabilities? Are they marginalized group? Are they indigenous communities? Are they people who have certain problems with accessibility through information provision? So start with understanding the stakeholders that is linked to your business. The second step is actually mapping your internal process. Whether you're a large company or a smaller company, doesn't matter. Chances are you already have some processes in place. So for instance, maybe you have a trade union already. Maybe you have some kind of ethics processes, some kind of ombudsman. It can be maybe with your suppliers, you already have some contracts in which you talk about the grievance mechanisms. It can be community-facing grievance mechanisms. It can be whistleblower policies or the speak-up policies. Chances are you already have something in place. And why is it important to actually map those? Because once you know what you have, it's always would be easier to get buy-in from the company management to introduce why is it important to have it for your supply chain. And it's also good once you know you can learn from the good points of these processes, learn from the gaps that already exist, and coordinate, harmonize everything in one. So once you identify the internal processes, you can look at external remediation ecosystem. Like in countries you operate, what kind of remediation mechanism are in place? Do your suppliers have strong grievance mechanisms? Are there local national contact points for OECDs? Is the judicial and non-judicial state grievance mechanisms, are they effective? Do your stakeholders have access to some kind of other grievance mechanisms or remediation mechanisms in place? What are the difficulties that they encounter when they want to receive remediation? So once you're done identifying your stakeholders, your internal processes, your external ecosystem, then you have several options that you can consider. And those options are really relevant to the sector, but also to the needs of the company. So for instance, some companies choose to open up their internal processes to external stakeholders. For instance, let's say if you already have a speak-up policies, you may consider opening up to external stakeholders, but then also trying to make it more transparent, more accessible, more legitimate, basically to bring it in line with the UNGP's effectiveness criteria. Second option, for example, some companies, they have international framework agreements with the global labor unions. Those are in those agreements, there are most of them, they have the provisions where labor unions and companies commit to jointly investigate the labor-related grievances. Another option would be to join the multi-stakeholder agreements in which there are grievance mechanisms. For instance, as Sociaal-Economic Council, we are facilitating a number of multi-stakeholder agreements. I'm leading one for the renewable energy agreement, which was signed last week, and there is a commitment for the sector to establish a grievance mechanism for the value chain for the complaints from the third parties. Another option would be to look for the industry associations. For example, Amfori has a grievance mechanism for its supply chain in Vietnam. And if not mistaken, they're also considering expanding into other countries such as Turkey. Another option would be, for example, there are worker-centric grievance mechanisms. International Accord is one option which they operate in Bangladesh, but they're also recently expanded to Pakistan as well. one other option and is related to establishing community-level grievance mechanism that is an attractive choice, for example, for companies in extractive and mining sector, where those kind of companies are basically taking a project and involving the local communities in running and designing the grievance mechanism, and those are quite successful in practice. Also, there are options. For example, some companies use commercial entities, companies like Lula, to establish stakeholder engagement and grievance mechanism. And those kind of grievance mechanisms are not only done through commercial entities, but for example, in Southeast Asia, there is local civil society organization who is administering and helping to set up those kind of grievance mechanisms. So there are a range of options are available for companies to choose from, and it's really dependent on the sector, on your value chain, on your suppliers, what fits your best needs. But there are several things to take into account. First of all, that you need to invest in your relationship with your value chain, and that means with your suppliers. So what I mean in there is that sometimes it's not only about you setting up a grievance mechanism for your value chain, but also stepping up and enhancing remediation mechanism in place by your suppliers. Now, the grievances or complaints, they are best handled in places where they occur. That's the fastest way for the victim to get a remedy. Of course, it doesn't mean that all the complaints should be handled there. There can be instances when it's not safe to do it, when workers are afraid of the retaliation. Or, for example, I just gave an example of a female worker who can be sexually harassed at the factory. You can't expect that the female worker will go to the manager who harassed it for lodging a raising this concern. So external grievance mechanism, your supply chain grievance mechanism from that perspective is always important, but investing in the remediation processes in place of your supplier would also be important if you want the remediation process to be fast and effective. And the second thing to take into account, what is important is to know that you're not alone. You need to share the responsibility of your value chain with others. It's not only your suppliers, but in some other instances, it's the other companies from your sector. Chances are they're having the same problems. We are hearing a lot of concerns from other companies. We want to set up remediation mechanism. We don't know where to start. And we hear it from other sectors, and there's a lack of information, there's a lack of cooperation, and it's important for companies to actually join forces just to learn from each other, like what's going well and what's not going well, what have you tried and what you can try more. So from that perspective, at Social Economic Council, we are also trying to facilitate those kind of discussions between the companies and between the sectors. And we would be working towards establishment of an access to remedy platform where companies, but also the labor unions and NGOs could come together and talk the remediation issues more in detail and learn from each other. I will stop there, Maria. I could go on further, but I think I would need to give time for others as well.
Thank you, Seljan. No, this was very helpful. I think we have a couple of golden nuggets that we could pull out of your input. So we do see the need and urgency once again to focus on complementarity, right, and harmonization, sharing responsibility, not only with the supply chain but also with other stakeholders. And I think thirdly, it's also, for me, it was quite clear to see that, now with the focus on mandatory due diligence, a lot of companies from several sectors are a little bit of running around trying to see what they can do. And I think you already pointed to us that there are systems in place and there are solutions already being implemented. So there is no need to work in isolation here. There are tools, there are other companies willing to share their experience. And I think it was also a great basis for me to say, this is why we're here. This is why our webinar now is taking place, in order to provide this tool for other companies, right? So thank you, Seljan. Now let's move on to our guest speakers from industry. We have first Charlotte Williams, representing the American multinational tech company Amazon. Thank you for joining us today, Charlotte, and helping us provide the audience with practical advice and lessons learned on setting up backup grievance mechanisms. So please, Charlotte, begin by telling us, how did Amazon decide to develop a strategy specifically for the access to remedy along the supply chain, and where has the journey taken Amazon?
Great, thank you. Well, thank you so much for the invite here today. Yeah, really happy to come and present and share a little bit of our kind of story and our learning so far. So our strategy basically started a number of years ago when we decided to conduct our first Amazon enterprise-wide saliency assessment. As you can imagine, it was a hugely ambitious project. Amazon is a very complicated business, touches lots of different industries, many supply chains, distribution networks. And so this was really our kind of first attempt to say, what are some of the most salient human rights risks that are affecting our business? And we took a stakeholder consultative approach to do that. Which involved many internal interviews with different stakeholders from different functions and parts of the business and different businesses. It involved many interviews with different human rights experts. And we took all of this feedback into our business and then benchmarked the results against internationally recognized human rights standards. And from that kind of huge body of work, this assessment identified a priority set of, salient issues. So we identified sort of 10 salient issues, and they included things like environmental justice, the future of work, other things that you would expect, like right to privacy, health and safety. And it's on our website, so I won't go into kind of too much detail about that. But importantly, in addition to these kind of 10 salient risks, we also identified what we consider sort of fundamental commitments. I think of these things almost as enablers. So things that we sort of have to do or think about in order to make progress against these salient risks. And they were a focus on rights holders, vulnerable rights holders, was one. The second was meaningful consultation with stakeholders. So to really kind of continue that journey we'd started with this saliency assessment, continue to engage with a variety of stakeholders. And then lastly, and importantly for this conversation, the last kind of commitment or enabler that we identified was opportunities for concerns to be heard and issues resolved. And I guess that very much speaks to the last speaker's point that she was making, is about grievance mechanisms, but it's also about responding to that and providing access to remedy. And so, this kind of thematic grievances, access to remedy, has recently been one of our key supply chain commitments, part of our kind of key due diligence commitments. And that's essentially kind of where our strategy started.
Okay, thank you very much for that. And on to the perspective of the grievance mechanism tool itself, now that we have an understanding of Amazon's journey to approach the subject, we know that Amazon strives to grant access to remedy for workers, amongst others, through the support of a third-party grievance mechanism operator. So in a nutshell, how does it work, and how this chosen path aligns to the effectivity criteria set by the UNGPs?
Yeah, sure. So let me just take a quick step back and just, describe our sort of Work of Voice program more broadly. So our Work of Voice program is essentially about providing kind of different technologies. Sometimes they're low-tech approaches, might be a hotline or a suggestions box or a worker forum, and sometimes high-tech approaches like worker apps and dashboards and ways of vending lots of complicated grievance data. in order to basically hear and respond to workers' day-to-day experiences. And as I say, we see this as a really crucial part of actually being able to make progress on those salient risks that we identified. But also more generally is really an important part of securing, important worker rights like a right to participation and right to remedy. And our strategy for worker voice basically takes kind of two approaches. The first is about connecting suppliers with a number of different global partners. Now, there's absolutely no one organization or one global partner that can meet the kind of complex needs of Amazon's business and supply chains. And so we have to work with a number of different types of organizations. And again, the previous speaker sort of touched on this quite a lot, that so some of those organizations we work with are multi-stakeholder initiatives like a moderator, which is a sort of industry NGO supported hotline based in Bangladesh, specifically for the ready-made garment sector. We work with an NGO called Project Isara based in Thailand and Malaysia. We also work with Amphori in their kind of Speak for Change program in Vietnam. And then we also, and this is the one that I will go into in a little bit more detail in a second, we also work with kind of technology companies, and our main partner is Alula. And so we also work with companies where there isn't kind of these industry initiatives or multi-stakeholder programs or NGOs on the ground. We work with these companies to connect our suppliers with ways of and technologies to help workers raise grievances and for suppliers to then be able to sort of respond and provide access to remedy while needed. So that's kind of the first part of our strategy, trying to connect our suppliers with these companies and with these kind of pieces of technology. And then the second part is about capacity building. So, just as this is a new topic for us, it's also a relatively new topic for our suppliers as well. We're all learning together. And so the second part of what we do is also provide opportunities for capacity building. So we've been working quite recently with ILO SCORE to develop a grievance mechanism component to their communication module. And we've been kind of testing that with a number of different suppliers last year. And we're also now trying to build a kind of e-learning program for some of our suppliers as well, to really help both kind of supervisors and workers really understand this subject in more detail. Really, what is a grievance? What does good grievance management look like? When should grievances be raised? What can they expect? Some of these kind of really basic questions kind of still need to be tackled. So that's essentially the kind of second part of our program. It's definitely not been a kind of easy journey. One challenge that I guess there are two challenges that we've really encountered from suppliers. The first is just this term grievance. It's a little bit jarring. We've actually tried to tone down the language, and actually we now talk about kind of reporting concerns. I guess suppliers feel like this has quite negative connotations. Workers are raising complaints, workers are raising grievances, and actually we really try to kind of communicate that actually, this isn't a bad thing. We all have concerns. We all face miscommunications in the workplace all of the time. We get our pay slips, we don't know what exactly everything means, why we've been deducted, what we've been deducted. These aren't necessarily big problems, but they are, miscommunications or concerns. And actually, it's much, much better for suppliers and management to hear these concerns and be given the opportunity to respond to them early on before they become kind of bigger problems, much more expensive to manage, much more difficult to resolve. And fundamentally, they also could risk, business continuity issues and supply chain disruption. So we've been doing a lot of work to kind of talk to suppliers about the fact that, grievances aren't necessarily bad things, but they're a really good opportunity, particularly if dealt with early, to just resolve kind of challenges in the workplace. And then I guess the second issue that we've been kind of struggling a little bit with is this idea that if there's a lot of grievances, that's a bad thing. And I know suppliers have definitely been concerned that, if we see a lot of grievances have come in from a particular site, that this sort of reflects badly on them, and that might affect their audit result or our internal performance, supplier performance scores. And actually, we've done quite a lot of work to try and say, that absolutely isn't the case. We're all aware when it comes to this topic, there's this issue of reverse causality. And actually more grievances absolutely doesn't mean that facility has poor management practices or poor communications. In fact, it actually could be the opposite, that workers are in a position where they feel like if they raise their concerns, they trust that they will be resolved. And so this is a really good thing. A worker who doesn't believe that issues will be resolved won't be raising these issues. And so we've really also done a lot of kind of communication to say, one, not only is the term grievance definitely not a bad thing, or concerns not a bad thing, but also, the more concerns you hear, the more opportunities you have to really make improvements to improve worker engagement. And there are lots and lots of studies that show, there are huge benefits to improving worker engagement, including productivity gains and reduced absenteeism. So there is also a kind of real business case here as well. And then I guess to kind of talk specifically about our kind of Alula program and how it works, which was your initial question. So the Alula platform has a number of different ways for workers to be able to raise concerns. And one of the reasons we partner with a Alula is because there are these kind of multiple ways to provide access for workers to raise concerns with management. So it can be done through a hotline or through a web-based platform, or through WhatsApp or WeChat in China. There's also a separate worker app in China that workers can use. And obviously that, providing accessibility to workers in multiple languages is one of the kind of UNGP criteria. So that was a kind of really important part of this program to us. And it was also really important that we brought in an independent body to administer this, partly because it means that they're able to give an unbiased view to suppliers. So if there's a concern that's been raised, they're not taking the worker side, they're not taking Amazon's side. They're here just to say, like, look, this is the issue, and to sort of provide some case management support and some advice on how to move forward with that issue. And also from the workers' side, it provides a sort of trusted, independent third party, so they don't necessarily need to kind of raise concerns directly to management. And so it was sort of really important from us, from both of those perspectives, to be able to bring in a third party. We just felt it would really help with those kind of trust issues. And essentially kind of workers raise these issues, and then Alula will respond and will provide some case management support if needed, some further investigative support, and where applicable will then kind of provide some advice on what good remedy should look like. So yeah, that's how it sort of works in a nutshell.
Thank you, Charlotte, and especially also for giving us a little bit of insight on challenges as well that Amazon has been facing on this journey. I think a great aspect I would like to highlight here is Amazon's constant attempt to engage in dialogue at industry level and to include local organizations to the conversation. This speaks of an approach that looks to strive towards more effectiveness in the grievance mechanism ecosystem. And at the same time, I hear that Amazon is also tackling the awareness raising of amongst suppliers. And I think this is something that industry could use a bit of help with. As you mentioned, it has been challenging, and this is exactly why this sort of platform exists. So we can learn from one another, and maybe this is a subject that we could use for one of our next webinars. Speaking of a standard. Thank you, Charlotte. And then I guess we'll move on to our next industry speaker, Simon Kraus from the s.Oliver group. So welcome, Simon. And so the same questions apply to you, of course. Could you tell us a little bit about s.Oliver's strategy towards access to remedy along its supply chain, and where has the journey taken s.Oliver?
Yeah, thank you, Maria, and also, of course, from my side, thanks a lot for inviting us today to the seminar. I think it's very interesting, and already myself I've found it very interesting and learned a lot also from the insights, and compared it to also how we approach the topic. I think for us the main three reasons when we look at the grievance mechanism, and the three reasons that we focused on when we wanted to to implement the mechanism was first, of course, we feel a sense of general responsibility towards everyone, and especially towards the workers in our supply chain, right? I mean, responsibility is one of our 3 core values at the s.Oliver Group. And then I very much agree with what Seljan has said. I think, of course, dealing with problems on the ground would be the best case scenario. But we also feel like that our presence and our involvement in some cases can be very, very helpful. And that's why, from our own responsibility, we always believe that having a functional and very operative grievance mechanism is a very good thing. Then the second reason, of course, touching also on what Gabrielle has mentioned, are the legal reasons, right? We are a German-based company that now, since January 2023, is subject to the new German due diligence law, which is actually under it, it's mandatory for us to have the grievance mechanism. So that was, of course, the case why we also said, okay, now we have to really look at it. And then thirdly, and I think that was also mentioned by Charlotte already, is that we also believe that the grievance mechanism itself, or focusing on problems that might arise at suppliers, is also something that is helpful for us, right, in the end, because we want to have, of course, smooth operations. We want to have good business relationships. We want to have as little problems as possible. And if we can, through the grievance mechanism, support our factories in having smooth operations, then that's, of course, also in the end a very big benefit to us if there are no problems in the production along our entire supply chain. So where has the journey taken us at the s.Oliver Group? Those were the basic elements. And we actually ended up choosing a multi-stakeholder initiative, and I can talk a bit about that later on. But why did we choose a multi-stakeholder initiative? Well, first of all, we very much believe that the synergy effects that come with working with a multi-stakeholder initiative are very, very important for us, are very important for the industry, and make our lives and the lives of everyone a lot easier. I mean, just as an example, last year at the end of October, I was in a factory of ours in Turkey and stood in front of their notice board and had to stretch my neck a bit to see all the different notice board information posters on different grievance mechanisms and different complaint helplines. And so we believe coming together in an MSI with different brands is very helpful, not only for that reason, but also then to increase, as we've heard before, also the leverage that we, together with other brands from the same factory, if they are also a member of the MSI, have at certain factories to say, okay, now let's please work on these topics that came up. So that was a very big topic for us. But then second of all, of course, we also very like the external involvement then of the MSI, right? Because for us, of course, then the topic is also new, and we very much profit of the experience in setting the system up from our MSI, but also then of their experience in the day-to-day operations of the system, in moving from the complaint to the remedy, where they support us a lot, where they share with us their experiences, their opinions, also bring in different stakeholders if that's necessary. So for us, that holistic approach within an MSI was very, very helpful. And we've ended up choosing, and maybe for some of you who are familiar with the textile garment industry, we chose the Fairwear Foundation, which is, I think, the biggest textile MSI in Europe. They have over 150 different fashion brands, European fashion brands, who are all more or less looking into the same things as we are. When we started implementing the grievance mechanism last year, we also saw, okay, we share a lot of our factories with other Fairwear members, so it's very helpful for us. And in that case, actually, the grievance mechanism was already operational without us doing anything. I mean, of course, we have to talk to the suppliers from our side as well, but the system itself was already there in the factory from the other brands and from Fairwear. So very, very helpful for us to have that backing. Nevertheless, to just also touch upon that, there were also some challenges. As we've heard before, right, we also need an internal grievance system, and we also, as part of the German Due Diligence Act, need to include environmental topics into our grievance mechanism, which is a bit tricky because the Fairwear system is very much focused on labor rights and not so much on environmental rights, which is why we also in addition to the fairware system, which is actually where most of the complaints are coming in, keep our own internal s.Oliver group hint box through which internal complaints, but also other complaints on other topics can be forwarded to us. And then the other challenges, I mean, I think Charlotte has already also mentioned about it, is right. Of course, it's very important to talk to the suppliers to highlight what we are planning to do with the grievance mechanism, that it's not something where we want to force anything on them, but that it should be a good basis for the dialogue that we have with them. And I think very important what she also mentioned. Please do not see a grievance as a bad thing. I think that can't be stressed enough. A grievance is or a complaint coming in is very helpful. It shows that the system is working. We can improve things. So I would much rather have a lot of grievances coming in than none at all, because then we also have to ask ourselves, is there something wrong with the system? Why aren't they coming in? Are they maybe blocked from putting in their complaints? So that's a dialogue that you have to have with all of your suppliers, and very interesting and can be very helpful also to build in on your relationship with suppliers for the future and other topics as well.
Thank you very much, Simon, for this thorough answer and the emphasis on your challenges. And I will definitely come back to one of those challenges later on. However, let's focus a little bit on your work or s.Oliver's work on with Fairware. So you have outed yourself. So you, s.Oliver works with the Fairware Foundation, a multi-stakeholder initiative. How does the collaboration look like? How does the implementation work on the ground look like?
Yeah, thank you, Maria. And I'll try to be very precise, so leave some room for questions also later. But basically, I mean, I said, right, we are using the Fairware system. So they have a very clear and structured system that we are then implementing at our suppliers. So to be very precise and concrete, we start with introducing our Fairware membership to all of our suppliers, tell them about the basic labor rights of Fairware, and also inform them then with these labor rights, workers would have a chance to hand in complaints if they feel that any of those rights is violated. After having these discussions with our suppliers, we put up posters actually or if they maybe in some factories there were already some posters, as I mentioned, from Fairware. We put up posters that inform the workers very glimpsable, I would say, on the basic labor rights that Fairware covers, and then on ways on which they can hand in complaints if they feel that any of those rights are violated. In the Fairware countries where Fairware has their own presence, there are phone numbers on there are email addresses on there. In other countries where Fairware is not present, there are email addresses on there. So there is an easy option for workers to actually get in contact with Fairware. We do some other things to raise awareness as well. We hand out cards, for example, to the workers when they leave the factory, so that they have the information and can also contact us at home, for example. And we then also have to provide proof to Fairware that we did all of those steps. We have to highlight to them, okay, we've put up the information sheet, we've done the communication with the suppliers, so that they are also aware of that we did all of that. But then very operational, once a complaint comes in, it is approached, or the complainant approaches Fairware, and they check if the complaint is valid, and forward the complaint to us afterwards, so that we can then get in contact with our supplier, talk to them about what happened, describe please to us the situation. We compare the situation to the complaint, and then try to find a good solution in exchange with Fairware, basically, and in exchange with the management, and in exchange with the one who put in the complaint. So it's very dialogue based, it's very open, and in all of these steps we try to make clear that we only want a good solution for everyone, right? We don't want to say, okay, now there was a complaint, we do not put in any orders now at the suppliers. So it's very open, it's very dialogue based, but I think going back to the effectivity criteria as well, it's very accessible, it's very transparent. Fairware publishes all the remediated complaints in the end on their website, so everyone externally can have a look at it. It's very legitimate, I think, with the involvement of the different brands, and also from our own experience, that's a very great step then to firstly check in the Fairware system. Are there other brands at the company, right, at the factory producing? Can we work with them together? And it makes things a lot it makes your life a bit easier, let's say, to work with other brands. And so I'd say, we've only had very good experience so far with the system. And of course, if you're interested in that, there's a lot of information also on the Fairware website on how the grievance mechanism works.
Of course, thank you. And here you have highlighted, of course, the work and the dialogue that you have to conduct with that s.Oliver has to conduct with its suppliers, and also you mentioned it as part of s.Oliver's challenge. This dialogue. Of course, can you say something more about it? So how does s.Oliver share this responsibility with its suppliers?
Yeah. Sure. I mean, first of all, I would say we also expect should ideally be the outcome of the dialogue with the management and the workers. Also, we expect a level of openness and honesty, and that comes with that what I've mentioned before, right? That a complaint is not a negative thing. So we really encourage our suppliers to be open, and I think that's the basis, a trustful relationships with them. But then, of course, we also know that we have to do a bit more, right, to also foster the dialogue on the ground. And it's very actually similar to what Charlotte said. We are also now working on social dialogue projects at our suppliers, right? How do we strengthen the relationships that the unions, the worker representatives, so basically every worker in the factory has with their management, so that, of course, ideally, and we've heard about that right at the beginning of today's event, backup versus actual grievance mechanism also in the factory, right? Of course, the ideal scenario is always that the grievance or the complaint is handled directly between a good dialogue of workers and management. So we really try to do a lot with trainings, but also with e-learnings that we're providing now, also based on the German due diligence law and the standards set in there. So that's one element that we do, but then also in working with the factories, we also make it very clear with them and try to support them as well in there, that we also expect them to sort of cascade the grievance mechanism downwards in the supply chain, also to their suppliers, that we would also like to hear about complaints there and would also then work together with them and the tier 2, tier 3 supplier on cases. And that's something that we are rolling out and that we are also aware of, that we need to do a lot of communication and dialogue again with the factories to show them the importance of that, and just have good relations with them on that as well.
Thank you, Simon. So yeah, this is pretty much in part to that what Charlotte also mentioned. So I can definitely highlight this challenge, and maybe this is for sure an issue to highlight in our next webinars, taking your suppliers along the way in the journey of sharing their responsibility when setting up grievance mechanisms. So thank you very much, Simon, for these insights. I think we can hear from your answers that s.Oliver has taken this task very seriously for some time now and decided to join forces with industry through an MSI, and not only to pool resources, but also to assure a certain level of or standard, right, when setting up grievance mechanisms locally. Thank you very much. I think this is a great segue to begin our Q&A and see if there are any questions that the contribution from the speakers generated, or maybe some other questions that we could not cover and that you would like answered. There's a question here. I would like to know more, especially from the company perspective. So a question for Simon and for Charlotte about how workers affected by business operations are engaged in the definition of remedy itself, and how their freely chosen representatives are engaged. And I think you already covered a little bit of this, but if you have something more to add, then feel free. Charlotte, Simon?
I can definitely add a little bit on that. So for us on the Alula program, as well as on a number of the partners that we work with, once a grievance has effectively been closed, so the case has been investigated and the remedy has been offered by the supplier, the complainant, the initial complainant, then has an opportunity to comment on whether or not, I guess, they're sort of satisfied with that remedy. Hopefully they are, in which case the case is then formally closed. If they're not, then the case is opened up again, and we start the kind of initial discussions with the complainant about their concerns, what more did they need, and that will then become a dialogue between Alula, the complainant, and the supplier.
Okay, thank you. Simon, do you have anything to add to that?
I mean, very much similar on our side, right? And maybe one addition, because I think I can't actually see the questions in the chat, but I think the question was also on the worker representatives and if they are involved. And I'd say also in cases where it's necessary and where we and also our other brands and Fairway have the feeling that, and that's the case where we should involve them, they are of course also involved, and we'll try to come up with a good solution with everyone who is part of the deal. Let's say it like that.
Thank you very much. This is a key aspect of what we said on including relevant stakeholders. Of course, the inclusion or integration of trade unions in the process is very much pivotal in assuring effective access to remedy. I have a question for Amazon. So, Charlotte, how does Amazon verify that the grievance is solved to the satisfaction of the complainant?
Largely through worker surveys. So we would conduct a specific worker survey to the complainant, and that's how we would get a kind of pulse check on whether or not they were satisfied with the remedy or not. And as I say, if they're not, then that complaint and that dialogue is opened up again. In addition to that, we will also conduct kind of wider worker surveys in the places where we are running these grievance mechanism programs to understand the potential impact of this program and the potential kind of trust and levels of engagement that exist within that factory as well. So it's done as a kind of individual case level as well as on a kind of broader programmatic approach as well.
Thank you very much for that. I have a question here on the chat. We have focused a lot on human rights during this session. However, I am also intrigued to find out a little bit more on what Simon mentioned. So the question says, what are some of the best practices expected from companies in relation to environment impacts? Is this a topic that you have tackled within your companies?
Yeah, I'm just thinking about it. I'm not sure if I have a straightforward answer actually to it, because I think from a systematic approach when looking at the system and at the complaint mechanism, I would say now that the topic itself is not so much not so important, right? Rather having the system in place, covering all different aspects, and then of course also raising the awareness of what the standards are that we want to have at certain factories or with our partners in our production countries, so that workers, for example, have the ability to see whenever there is something that is going against our own environmental standards, that they can then raise a complaint. So this awareness raising might be a bit different than the awareness that we would usually have for other, let's say, more traditional topics that would come into the complaint mechanism, like non-paid wages. But then in the end, I would say the system itself should be in place and functional, and then from there you can work on improving that step by step with the complaints that are coming in.
Sure. And then I wanted to highlight the question simply because this is being emphasized, at least in the German due diligence law, there is the need to report environmental damages as well. So I think it's good that we invest as well in dialogue regarding these topics. Charlotte, do you have any input on environmental issues, or? I have other questions for you.
Yeah, nothing particularly in addition to what Simon's just already set out. It's definitely not front of mind for workers at the moment. And so potentially there's a little bit of work there to do that kind of awareness raising.
Great. Okay, thank you. I think this is as well a question for both of you. So how are you measuring the effectiveness of your grievance mechanism measures? And I think both of you have brushed upon this, but maybe in some summarizing points on it.
It's a really good and really timely question from our perspective, actually. So at the moment, we're largely focused on measuring outputs. So number of grievances, number of resolutions, percentage of workers satisfied and things like that. But we definitely want to get much better at measuring efficacy in line with the UNGP criteria. So really trying to think about, what does it mean to measure access, to measure that requirement around feeding your grievance data into your process of continual learning and risk assessment. And we're just building our monitoring and evaluation framework to do that in line with the UNGP criteria at the moment. So more to come on that. But I say at the moment, we're more focused on kind of output metrics rather than percentage indicators.
And maybe just sorry, just adding on that, we also have, of course, certain numbers and KPIs that we include in our internal reporting as well, of how many cases came in, how many cases were then successfully remediated. But of course, then in the long run, and that's something that we are also still working on, the development of that, right? In the long run, of course, the measurement of how successful we are with our system should be a reduction of the risks that we identified our suppliers through our annual risk analysis. I mean, that will be the best case scenario, that in a couple of years, and of course, that's not only the grievance mechanism is paying into that, but also other measures that we take. But ideally, of course, all these measures combined, they should in the long run bring down the risks that we identify and the risk scores that we identify in our risk analysis. And if that is the case over the course of the next couple of years, then we would also say, also in terms of this risk-based approach, these systems are very effective and helpful for us.
Thank you to both of you. I'm gonna squeeze in one last question, and this is free for grabs. I think any one of you could answer this, and it's a good one, which I think we will have to address as well in one of our next webinars. So, how can we ensure a fair representation of workers in all grievance redressal mechanisms, so that it's not just a company decision on what is a grievance that deserves remedy? Nobody feels up to the task to answer?
Maria, I can start.
Sure.
So yeah, I can start and maybe others can complement to it. When we are consulting companies about the design of the grievance mechanism or remediation mechanisms, we always advise to engage stakeholders in the design, but also in the functioning of the mechanism. So in this case, stakeholders include the workers, the worker representatives in countries where the labor unions exist, also the labor unions, so and the civil society organization, NGOs, and etc. To actually to have a conversation with them first to understand what the needs are, where the gaps are, and design the grievance mechanism based on the need. And if you already have a grievance mechanism or remediation process in place, also having consultation with them to see like what can be improved. So engagement with stakeholders all the time. But when the grievances are already lodged, one process that can be helpful is, for instance, consulting with the victim, like what kind of remedy he wants, what kind of remedy will satisfy him. And also having in mind that sometimes the victims are not aware of their rights. So you also need to make sure that the remedy is rights compatible with the International Human Rights Convention. So having consultation with them is also important. Another third aspect, for instance, what we also recommend companies to do is when they use the third parties, even like companies like Ulula or the other commercial entities, you can use the local in the complaint handling, mediation, and the dialogue phase. You can use the labor unions, you can use the local civil society organization, the human rights defenders, so that to involve them in the process, because yeah, the grievance process, it always, if it's the company process, it will always be felt from the worker perspective as a power imbalance. And you want to make sure that they don't feel it like that. You want to make sure that the worker representatives are involved in that process. So I think this will be one of the topics that we will further elaborate in the next webinar. So I will stop there.
I might just quickly
Thank you.
add something to that, Seljan. I completely agree with everything you've just said. I think it's a succinct account of it. But just to say that there's an additional driver that might come from legal developments, because there are in some of the emerging laws and regulations that I outlined, some indications there might be requirements to consult stakeholders on various issues. The EU's Corporate Sustainability Due Diligence Directive proposal does include stakeholder consultation. At the moment, the Commission's draft in a fairly weak way, but that's currently under negotiation at the Parliament level. So it may be that there are legal requirements to include stakeholder perspectives in the design of grievance mechanism, what is appropriate remediation. So these are likely to come, and that's likely to be another kind of incentive to properly engage with stakeholders.
For sure. So this is turning to be a mandatory process, right, that needs to be integrated in grievance mechanisms, so it's no longer a choice. So just because I'm keeping time in mind, and I see that there's a lot of questions pouring in now in the last minutes, but as I mentioned at the beginning, we will try to sort the questions and try to provide an answers where we see that we're able to do so, and of course we will then send you the answers afterwards. So I think I will stop here, and thank you very much again to all of our speakers for today and for these great insights and perspectives and learnings. And thank you to our audience as well. I hope that we could help you through the several inputs to reach a better understanding on corporate expectations and how to address these from a practical perspective. I think what we can take as key messages from these sessions are, firstly, a distinct level of urgency and proactiveness towards setting up grievance mechanism. However, and is equally important, prioritizing collaboration when setting up these grievance mechanisms is key. Regardless from approach, we could hear that involving local stakeholders and engaging in serious dialogue with stakeholders outside of the own company at industry level, local level, to learn and to build up on already existing expertise and experience is also crucial. And lastly, engaging in responsible and committed dialogue with the supply chain and embracing their awareness to the topic is also pivotal and probably one of the most challenging aspects. Nonetheless, there is no way around it. And on this note, I would like to leave you with a plea to change the perception that responsibility to implement HREDD is passed along the supply chain in order to assure compliance, but rather that responsibility is shared through high-level conversations, mutual understanding, and a worker-centric approach. So for our next sessions, we decided to let the conversations steer us. Therefore, your feedback and your questions are very important. Which challenges would you like to see being addressed through practical advice? Which area of learnings would you like to see featured? If you're a company that would like to share its learnings, please do contact us. We will be soon sending the invitation and with the selected topics and speakers. So this is all from my side. Take care and see you during our next webinar. Thank you very much.